Cool. So Nick, your question is, sure, and now I forgot what your question is. Sorry, it's been a whole 10 minutes. And now the question just slipped my head.
No,
but yeah?
The clients who's got the Airbnb properties.
Oh, right.
The long-term lease coming up.
Yeah. And so the question here was around whether, so if a person, for example, runs Airbnbs and they have bookings, say, for December, but they get this really nice tenant and this tenant wants to stay there long term and they want to sign a long-term lease. The question here is whether in that long-term lease, a person can include a provision that basically puts the responsibility or obligation on the tenant to, for starters, understand that one is actually cancelling bookings, right? And there's a cancellation fee that applies to those bookings. So this person is actually suffering damages, but they would rather have a long-term tenant and they don't mind cancelling. But if this long-term tenant goes and tries to cancel the lease, you know, that early termination in terms of the CPA, if they go and they cancel it early, obviously the landlord is going to end up suffering because now they cancel decent Airbnb bookings. The question here is, can the lease agreement make provision for this so that the tenant pays the landlord for these actual costs or damages that the landlord suffered?
Perfect. So we are once again then talking about Section 14 of the Consumer Protection Act in the circumstances. So we've done Section 14 a lot on this particular channel, but for those who might be logging in today, Section 14 of the Consumer Protection Act basically has a situation where there's protection provided for consumers of services in respect of fixed-term agreements that are entered into between parties. And what Section 14 allows is that a consumer of a particular service is entitled to terminate an agreement entered into for a fixed-term period between themselves and another party early by giving 20 business days notice to the other party, but their entitlement to cancel the agreement early is subject to them being liable for a reasonable cancellation penalty. Now, just before I go on, I want to distinguish two circumstances. So there are circumstances where the CPA, the Consumer Protection Act, is going to apply to your particular agreement, and then there is this provision within legislation that says you are liable if you cancel early for a reasonable cancellation penalty. Then on our other side here, we have agreements where the Consumer Protection Act does not apply. Okay. And both of these circumstances we have to deal with for this particular question. Okay. But what is important to know is, in terms of legislation, okay, the Consumer Protection Act, if that applies to your particular agreement, okay, the legislature has put in safeguards for a consumer of a particular service to say that the liability that you have for the early cancellation of that particular agreement must be a reasonable cancellation penalty. So they're essentially trying to put a roof on what can be claimed against you as a result of the early cancellation of the particular agreement. They're trying to limit the amount of that you can be liable for, because they're obviously trying to protect the consumer of a service in this particular circumstances. If you are not in that camp, so you have an agreement that's entered into between parties where there is no applicability of the Consumer Protection Act for whatever reason, there is no limitation. Okay, so when you are liable for a damage, you're liable for, in South African law, what you can prove is a damage that has been suffered. So in circumstances where the Consumer Protection Act doesn't apply, no problem. If you can demonstrate, the question today is, can I hold people liable because now I've cancelled bookings on the assumption that this person is going to rent my property, and if they don't rent my property, can I get that money back? In circumstances where the Consumer Protection Act doesn't apply, absolutely, because you can demonstrate that you cancelled bookings on the strength of the representation that they were going to rent your property. So there's a clear path there. When it comes to the Consumer Protection Act, it's a bit more complicated because, as I say, the legislature is now trying to protect the consumer of a service a little bit and make sure that there's a limitation on how much can be claimed against them. But as we have dealt with many times when we talk about Section 14 of the Consumer Protection Act, what is reasonable in terms of the legislation is not defined. It has been left open-ended because it will depend necessarily on the facts and circumstances of the particular case. Okay, so what is reasonable in respect of one lease agreement might not be reasonable in respect of another, and that will depend on the facts. Okay, and today's question is a classic example of the facts playing a factor on the particular lease agreement. Okay, so in this particular case, what we are told is that the person who is renting out the property generally does Airbnbs. They've got bookings for December already, but they are considering whether to take on a long-term tenant instead, which would necessarily mean that they lose their bookings for the December period. And so this is something that is absolutely a factor that would be taken into account as a reasonable cancellation penalty in the circumstances. So this is something that the facts of the particular case should be considered. That's something else that you suffered, rather than a normal sort of lease agreement where you say, well, I'm suffering because I just don't have a rent in the circumstances. So this is another factor that can be taken into account. Absolutely something that can be taken into account for the purposes of calculation of what is reasonable in the circumstances. And particularly, our writer has asked whether it's legal or permissible to include a clause in the lease agreement that recognizes that this is going to happen in the circumstances. And in that regard, we absolutely say yes. Okay. If you have a specific need or a specific intention with regards to entering into this particular lease, it is absolutely critical that you include that into your lease agreement to pay cognizance of the fact that that there is something that has happened in this particular case which needs to be recognized. And remember, also very important, if you are signing a written lease agreement, you're going to have a boilerplate clause that says that the written agreement is the whole agreement between the parties. So in those circumstances, it's even more critical to make sure that you recognize, you write down exactly what led up to this, and if there is a potential damage, that is recognized within the particular agreement. So yes, in these particular circumstances, can you take it into account? Yes, it's something that is a factor in this particular set of facts that we're presented with. Should you write it into your agreement? Yes, absolutely. Include it in the agreement to make sure that all parties understand the agreement that's being entered into and what the potential risks are with respect to that agreement.
Got you. Awesome. Thanks so much, Nick.
Perfect. Thank you, Bruno. We will see you next week.
Cool. Have a good one.
Yes.